The Supreme Court of India Constitution Bench, led by Chief Justice Sanjiv Khanna, has concluded and reserved a judgment in a pivotal case concerning the power of the court to modify the arbitral award under the Arbitration and Conciliation Act 1996. This case, which has seen extensive arguments over the several days, centers on the interpretation of Section 34 and 37 of the Act, which deals with setting aside the arbitral award. Section 34 of the Arbitration Act allows court to set aside the award on specific ground like patent illegality or violation of public policy. Now, there were two arguments taken in the court, one against the modification and one for the modification. Mr. Tushar Mehta, the Solicitor General of India, representing the Union Government, strongly argued against the court's power to modify it. He emphasized the legislative history of the Arbitration Act from the years 1899 to 1940s till today, which shows a deliberate omission on the part of the legislative with respect to the power to modify it. He pointed out that the 1996 Act was based on the UNCITRAL model law, which was intentionally designed to limit judicial intervention, focusing on setting aside the award rather than modifying it. Now, Mr. Mehta further argued that introducing modification powers would encroach upon the legislative domain. He also highlighted that allowing modification could lead to practical difficulties such as enforceability's issue in the international arbitration and the potential increase of litigation as the parties seek to cure the defects in awards. Now, on the other side, senior advocates like Mr. Arvind Atal, Mr. Giras Kambata, and others argued that courts should have the power to modify these awards to ensure speedy and effective dispute resolution. This aligns with the Act's objectives. They contended that the power to partially set aside the award inherently includes the power to modify it. Mr. Kambata emphasis on denying the court power to modify it would lead to unnecessary delay and inefficiencies. He argued that the power to set aside and include the power to modify, which is smaller subsumed power. He also argued that the current system, where the award is sent back to the tribunal for correction under Section 34(4) is not a true modification and often only allows the tribunal to fix reasoning, not necessarily the final discussion. After hearing both the sides, the key issues and the court observations were basically on defining the modification. So the court emphasized the need for a clear definition of modification and its parameters. The court sought to balance the need of judicial oversight and the principle of minimum judicial intervention arbitration, thereby balancing the judicial intervention and finality. The court considered the potential impact of modification powers on the international enforceability of arbitral awards. And lastly, but not the least, the legislative intent, which was behind the history and the intent of the Arbitration Act. The Supreme Court's decision in this case is eagerly awaited, as it will have a significant impact on the landscape of the arbitration in India. If the courts rule in favor of the modification power, it could streamline the arbitration process and reduce delay. However, it could also lead to increased judicial interventions and potential challenges in the international arbitration sphere. On the other hand, if the court upholds the current interpretation of Section 34, it will reinforce the principles of minimum judicial intervention, but may also perpetuate inefficiencies in the system. The decision will set a crucial precedent on how the courts can handle the arbitral awards in the near future.